All right, guys. Welcome everyone to the special education law, and this is going to be a guide not just for teachers, but for teachers, parents, and students, because everybody should have an idea of the law in terms of special education. So this is going to be like a full training. Okay, it's kind of like a mini course on a special education law, and a lot of it's going to start off on like some history on how we got to present day laws, and then it gets really into detail and stuff. We'll talk about specific landmark cases and individuals with education, I.D.E.A. law, all that stuff. So let's just get into this here, right? So I'm going to hit present now. I'll make this PowerPoint available on the description, etc., and so forth, right? So let's get going. So first off, I already have a short of condensed version here of a video. It's on special education law, and a lot of these infographics will pop up in this presentation as well. But this is a short one here. It's like I don't know, about 7-8 minute video. And it's a nice overview of some of the important laws, especially it's a short history of, let's say, federal laws for students with disabilities. So I'll make that available as well. So let's get right to it, right? So in this presentation, it's going to be like a summarized version of the most influential special education laws to date. And it's good to have an understanding of these laws because it will benefit special education teachers and parents of these students. Everybody needs to know the law. And nowadays, a lot of times when parents come to an I.E.P. meeting, a lot of school districts, good school districts, they'll immediately hand a parent like a special education rights little pamphlet or something like that, and it's kind of like an olive branch, and it's just like this is for they'll give it to the parents. They'll be like, it's important that you know the law too, just in case we do something wrong, the school district. So we're going to start off here. So we're going to work chronologically. We'll start off with some of the most important laws, and we'll start off in 1965, which is the Elementary and Secondary Education Act, and we're going to see how we work our way to present day. So some of the key provisions here we're going to go over. So it was signed into law by Lyndon B. Johnson in 65, and it's known as Public Law 8910. So public law will be shortened to PL. So whenever you see a PL, like PL 8910 or something, that stands for public law. And it's often abbreviated. A lot of these have abbreviations too if you want to look them up on your own. ESEA by educators. So the law was brought to the table along with other legislations for President Johnson's. It started with what's called the War on Poverty. Okay, and ways to fight the war on poverty. One of the best ways is to one, educate the students, but kids that are in school, there's things more important than just education, such like school lunches when we're fighting the war on poverty. So let's see here. So ESEA includes provisions for a free and reduced lunch programs. Okay, and there were some in place at the time. This law also brings initiatives that are designed to help low income families get access to high quality education. That's still a fight that's going on today. Provisions to increase the number of teachers in low income sectors. That's, again, this still goes on today. And a focus on equal access of education. So, equal access. And it's kind of shifted now where we're looking at equality, equity, and things like that. But at this time, they're just looking at equal access of education, meaning able to go to the same high quality schools. So the law's lunch provisions were built upon the National School Lunch Program that was started in 1946, and that was started by Harry Truman. And the overall goal of ESEA law is to give educational and financial support to children that need it most. The law has been reauthorized into the famous No Child Left Behind Act, and then that's reauthorized into the Every Student Succeeds Act, which is in place right now, ESSA. All those we'll get to. So during the time, and actually still to this day, there were large achievement gaps between wealthy and impoverished schools. Okay, still going on today, right? Funding, but it was much worse back then, I want you to understand. So funding was authorized for the following. So this is the funding that this act put forth. Professional development, instructional materials, parent engagement opportunities, and support systems for students. So 65, now we're here in 73. In the Vocational Rehabilitation Act and Section 504, which we all know about, that's still taking place in education. So this aims to protect individuals from discrimination on different levels. So discrimination can happen in a lot of different ways. and to different subgroups and things like that. So, this act guarantees a number of rights for individuals with disabilities. So that's what it's focused on here, because again, this is special education law. It sets the precedent for many laws to follow. And affirmative action programs were established in sections 501, 502, 503, 504. So these are important laws, not just for education. At the time, individuals with disabilities were discriminated against for the fact that they were often viewed as below average. Okay, and when we're looking at laws back in the 60s and early 70s, that's when special education started to really make a turn, and a turn for the better, I would say. Before the 70s, there really wasn't much rights. And if you look back to like the 1800s and things, when students, special education students that special needs kids were denied school back then. They weren't allowed into schools. When they had their own schools, some of them were like institution-like. It was really a bad time. Prior to the 50s and things like that in special education. So the 70s was when we started making that turn, and that's because of these laws. So if you're ever if you ever looked like activism and things like that, and it's all great, the goal should be to put laws in place. I see a lot of there's always protesting and things like that, but protest should lead to something changing into a positive law. So again, at the time, they were discriminated against, individuals with disabilities, and they had to face challenges of physical barriers to work in school. And the law also states that employers of individuals with disabilities must make reasonable accommodations for their desired employees. So this isn't just about school, all right? Reasonable accommodations is something that's really important too, because some people take this the wrong way, and they think that individuals with disabilities can get any accommodation, like not having to show up for work. No, they still have to show up to work, but it's a reasonable accommodation. That word reasonable is very important. Now, although employers must make reasonable accommodation, that does not, however, mean that they must hire unqualified individuals. Okay, even if the person has a disability, they still have to be qualified for the job. Furthermore, if the disabled individual happens to have a contagious disease or pose a danger to others in the workplace, the employer doesn't have to hire them. Doesn't have to hire an individual with disabilities. But if they do hire that, they can't discriminate against them for the disability. But they also don't have to hire that person as well. 1 second. What's up? Okay, I just got to be quiet. Okay. So furthermore, we said it can't pose a danger to others in the workplace. All right. So Section 504 is the first disabilities civil rights law. Okay, enacted here in the United States, thus making it very historic. It ensures that students with disabilities have equal access to education as other students. And the law is the basis for the Americans with Disabilities Act, one of the most famous laws, ADA. It's going to come up later in the course. So 504 is the basis for ADA. Americans with Disabilities Act, ADA. So let's just a little review here of 504, right? And remember, Section 504 is a part of the Rehabilitation Act. So a student is defined as an individual with a disability if they have a mental or physical impairment that limits major life activities and functions, and a record of it. Okay, that's very important too. That's why I underlined it. It has to be a record of the impairment. You have to be able to prove it, right? So, and then it has to be sort of continuous. So major life experiences. So major life activities include breathing, concentrating, walking, speaking, learning, self care, manual tasks. So if you're not able, if a child is not able to, concentrate or walk or speaking, you know what I mean? If they're then it's an impairment, and then they're eligible for a 504 plan. So for a student to be covered under Section 504, they must be qualified, and they must be between the ages of 3 and 22. Okay, and again, major life activities. Think, what are major life activities? Breathing, self-care, all that stuff. So Section 504 of the Rehabilitation Act in review, right? So examples of impairments. So these are some examples, okay, of impairments that you might fall under 504. Long-term debilitating illnesses, epilepsy, chronic illness, severe allergies. I have terrible allergies, diabetes, many, many more. 1 second. Very sorry about that. All right, so anyone can refer to a student for evaluation under Section 504 to determine if the child is eligible for 504 services. A committee must be in place, and it consists of educators and others that have knowledge of the student in question. 504 committees look at the child's overall academic progress, teacher evaluation, observations, much more. And very important, the parent must be notified. And this trend comes up a lot in this special education law training, especially as we go on to the I.E.P. will be coming up soon. So Section 504 of the Rehabilitation Act, again in review, here are some accommodations meant for 504 students. Extended time, enlarged print, oral assessments, books on tape, graphic organizers, behavior intervention plans. Okay, this is a short presentation. I'll try to link this here, just on the least restrictive environment. All right, I'll put that link so you just go back real quick. And here's a little infographic available. Talks just a bunch of information on 504. And this is from one of the videos. I've created a video on a 504 plan. Just take a look here. Okay. All right. So again, the big takeaways from this law here is that it prohibits discrimination against students with disabilities in terms of federal funding. Okay. So if money is being given at the federal level, you cannot discriminate and not, give that money to students just because they have disabilities. It also provides a definition of the term appropriate education. Keyword there, appropriate. So many educators today are familiar with students with 504 plans where accommodations are described. Okay, I keep going. Educational Amendments Act. All right, maybe not one of the most popular ones here, but I'll try to go over this a little quickly. All right, so the Educational Amendments Acts give students the right and families to the right to due process. Okay, due process includes a fair treatment through a normal judicial system. Especially in special education law cases. We'll get into some detail on that. So during the time, the Office of Gifted and Talented was initially housed in the U.S. Office of Education and was given official status. Okay, federal funds are given to states for programs, for exceptional learners. So this is all under the Educational Amendments Act. All right, now we come. I kind of wanted to go over that fast. This is probably the most important law, for special education. 1970. This is the turning point here. Okay, this is the turning point. All right, so the Education for All Handicapped Children Act of 1975. I remember when my professor went over this in grad school, and she specifically said how important this law was, and she made us, write papers on all that stuff. So, the Education for All Handicapped Children Act, abbreviated right there, EAHCA, has many accomplishments and was enacted in Congress in 1975. The law was eventually reauthorized. So, to the Individuals with Disabilities Education Act, I.D.E.A., which is very popular, we're going to get to. And then that was later improved upon in 1997 and amended to the Individuals with Disability Education Improvement Act, again in 2004. So you can see it's continued to get improved and reauthorized upon. So this is the foundation here. Some call this law the backbone of special education. Okay, the law guarantees a really important concept, what's called FAPE, which is a free and appropriate public education to all students with disabilities for any school accepting public funding at the public's expense. This was monumental in ensuring that special education students were afforded services that they needed. FAPE, FAPE, FAPE. Always think about that. Free and appropriate. Okay, this think about it. Your child doesn't have to pay for the right for education, and it has to be appropriate, okay, for that child. Educators were forced to make fair decisions on the type and kind of educational services received. The least restrictive environment, also abbreviated LRE, is defined as an educational environment where students are placed with their non-disabled peers. Okay, special education students shouldn't be excluded from general education students. All handicapped students should be placed in an LRE based off their academic, social, and emotional capabilities. Now, the LRE is also seen as a pyramid because some students are more severe, so they'll have limited interaction with non-disabled peers, and some students are just are able to spend all day with non-disabled. Some disabled students will fit in perfectly well. So it all depends on the situation. Now, students can be placed in separate schools with their disabled peers only if their academic goals cannot be met in the regular education classroom. So there are a lot, especially here in New Jersey. There's a lot of separate schools just for special education students, but the goal isn't for students to be placed there. That's only if it's necessary. The goal is always to push them up this LRE sort of ladder, in a sense, to the top, where special needs students are spending the majority or all of the time with non-special education, with other non-disabled or non-special education students. This is a short video I put together on the LRE, and here's a great infographic I have. Let me go back a little bit. You can see general education classes at the top. Here's the goal, the ladder, inclusion, resource room, self-contained, all this stuff here. So just take a look at this. You could always pause this when you go back. All right, so the Education for All Handicapped Children Act is often referred to as the mainstreaming law, also a popular term, right? Mainstreaming occurs in schools when students are placed in the general education classrooms during different periods of the day. They call it mainstreaming the student. They're trying to, give that student as much access to the general education curriculum and general education classes as possible. So, for example, special education students with strong math skills may be placed in a general education math class, and if they're weak in, let's say, science, then in science they won't be in a general education class. They'll be in a pull-out replacement class, or they'll get more smaller group learning. So it is understood that children with disabilities should spend as much time as possible with their non-disabled peers, which today is met by the mainstreaming in the general education classroom, when students are able to be academically successful. So they have to be able to do it too. You don't want to place a student in, a general education classroom if they're not going to be successful though. Then that's poor placement. So students and their family or guardians are entitled to due process. Okay, and so due process relates to access to judicial review to determine if parties have met their legal obligation. So basically what's saying is, the courts can, when you hear due process, that means they can get involved. The school can't just say, oh, I'm doing this, it is what it is. That's why we have due process now. That's what makes this so important. So Congress agrees to fund up to 40% of excess costs of special education. Children physically or physically or mentally disabled are entitled to at least one free school meal per day. At least one. Such an important part of this law. Also, handicapped children must be evaluated by their own public schools districts, and it has to be at the expense of the district. If you want to know if your child is, if you're worried if your child is has some sort of a learning disability, you don't have to, as the parent, you don't have to pay for, the evaluation. The school will pay. You can pay for your own evaluation, which we'll get into later, and then, you can have it to pay, and then you might have to go to remediation and all this stuff, and you can pay for your own, but the school also must pay and do an evaluation. So that evaluation is used to, the evaluation is often used to create an individualized education program, or sometimes it's called plan, specific to the child's ability, the I.E.P, which we're going to get into. Now, the education plan should be developed with input from the parent and designed to give the child the best possible chance of success. Whenever developing these IEPs, it's always best to get the parents' input, because they're the best source of information on the child. Okay, and the IEP must place a child in a position to be successful. And again, this is all, Education for All Handicapped Children Act, such an important one. The law states that the rights of students and their parents are protected under the 14th Amendment and its Equal Protection Clause. Okay, it's reiterating that, right? Under the Equal Protection Clause, no state shall deny any individual within its jurisdiction equal protection under law. Okay, equal protection. Everybody gets the same treatment. Child find, very, very important. Schools are required to attempt to find students with disabilities. It's called child find, and refer those students for special education services. Many parents and children are in denial about if they have a disability. I understand why. They don't want to be labeled. So, maybe they don't talk about it. Maybe a disabled child, has a parent that's not really watching them, or the teacher's not watching them. So they're not, you don't want children to fall through the cracks. That's why this child find is so important. And the schools have to find them. So there's a lot of, like today, there's intervention and referral services, response to intervention plans. There's a lot of intervention in place to identify these students. So, we're school systems are doing a much better job. All right, so we talked about that one. Education of Handicapped Act amendments. All right, so we'll do some amendments here. So this was enacted in 1986. It's known as a public, again, PL is this public law, 99 457. And the overall purpose and goal of this act is to provide increasingly better services to young children and their families. So here in this year, 1986 one, we're focusing on young children and their families. So the most important success here is that free and appropriate education was extended from children ages 3 to 5. And I always want to double check that number, make sure I didn't write in the 3 to 5. Whereas before began at age 5 through 18. It requests early intervention programs for children with disabilities from birth age. Okay, so now we're talking about early intervention as well. So again, this 1986 law, it's focusing on early childhood. The law created the Handicapped Infants and Toddlers Program. The program was specifically aimed at children with developmental delays and other disabilities. It also assists states in implementing these programs for very young children. Okay, and there's so much research out there that shows that getting children, early intervention pays off in the long run. There's so many studies out there, and my son, when he was 3, no, less than 3, I guess 2, and he wasn't speaking up, and he wasn't saying the words he's supposed to be saying or something like that. So we wound up calling early intervention, and they gave their battery a test. It's 5 different areas they tested, and he was behind in speech, and we were able to get him into speech at that age, and they worked with him for about 2 years, and he's 5 now, and he just comes in and talks, and it really helps out. It worked for me. Okay. All right. So I mentioned this earlier. The Americans with Disabilities Act, 1990. All right. So it builds upon the civil rights laws of the 1960s. Okay. Also, and such an important law. And an important aspect is that it prohibits discrimination in the workforce. Okay. So this is really aimed at the workforce. The law prohibits discrimination on the basis of sex, religion, sexual orientation, race, immigration status, all that stuff. ADA aims to create for everyone an equal opportunity to employment, accommodation, services, transportation, etc., etc. Okay, remember, this is a workforce-based one. Equal opportunity is provided to a broad number of people. This includes HIV positive, people in wheelchairs, anybody that's really going to be at a disadvantage. ADA makes it illegal to discriminate against people with disabilities anywhere, and that's important. It's illegal, meaning they can get sued now, which includes school systems, and that's why you might be saying, why am I talking about ADA here? If this is like a teacher side and we're talking about special education law and I'm talking about the workforce, you're saying, oh, how does this relate to schools? Yeah, because this law includes school systems. Okay, school systems are under the umbrella. So ADA offers students with disabilities protections. However, other laws such as 504 and I.D.E.A. provide even more protections. So children with disabilities, special education students, or let's say they're not classified, they're not yet special education, let's say they're just, children with disabilities, they're provided with laws with protection from ADA. However, once they get, an I.E.P. and 504, they get more protection. But it's important to know this here. So here was a little short video on ADA, and here's an infographic I created, just a quick little overview of reasonable accommodations. Remember, ADA is based on, you can't discriminate. But again, remember the words that we talked about, reasonable accommodations, right? So if you look at this little image here, like this person can't enter the can't get to the work entrance, so they build a ramp for him. It's very easy. That's a reasonable accommodation here. Okay, an unreasonable accommodation is if this person I say, I only want the best. I need you to buy me a top of the line computer. That's an unreasonable accommodation. So reasonable accommodations are here. Okay, if this person has diabetes and they need a 5 minute break in the day, for an insulin shot, that's reasonable. Okay, but like down here, like saying, okay, I need, saying, oh, I need 3 hours off for an insulin shot, then that's unreasonable. Or saying let's something really 7 hours or whatever. Okay, so ADA directly requires that employers must provide reasonable accommodations. Reasonable. The law also establishes the public accessibility requirements, where buildings, products, and services are designed in a way to make them feel readily available to individuals with disabilities. And you can see here like a reasonable accommodation right here on the side. Look at the little, the little handrail to help. There's many reasonable accommodations that can be made. All right, now we're getting into the big time here. Okay, I.D.E.A. 1990. I'm just gonna take a little sip of coffee. Okay, so just take a look here. These are some of the topics we're going to cover, and let's get to it. So it was enacted in Congress, Individuals with Disabilities Education Act. It's abbreviated I.D.E.A. 1990, and it renames that very important law we talked about, the Education for All Handicapped Children Act of 1975. And this law, I.D.E.A., in 97 and 2004, it's amended again. So the intent of this law was to make needed improvements. Okay, they just amended, make some little improvements that include transitional programming, evaluation of students, procedural safeguards, very important. So in this law, it states the purpose. So they say, what is the purpose of this law for people? Why are we taking the time of creating this law? So one, we mentioned FAPE before, but we want to mention that FAPE now has to be respect with the child's unique needs. And, the word unique really fits with special education because every child's different here. So, it pushes schools to be a little more individualized. It also aims to protect the rights of special education children and parents, okay? Provide assistance to the states and school districts. Remember, it's never easy for school districts to handle all the paperwork that goes in and out, and it's, the truth of the matter is there are some schools that hire way too many staffs, and there's people that don't do anything and have these jobs, and then there's some schools where you've got one case manager or one special education teacher doing all this paperwork, and it's not fair. So you never know. So some schools do need assistance, some schools don't. It's also meant to prepare educators through research-based knowledge. Okay, secure materials and tools, and assess the effectiveness of special education programs. That's we're going to look a lot into detail. So you have to assess and see if these programs are working for these children. And so here we're talking about evaluations, right? So evaluations to determine a student's eligibility for special education has to be completed through a process. Okay, so every state's going to have their process. Evaluation should limit the number of misidentifications and identify students that are in need. There are a lot of misidentifications. It's always worse to it's always worse to have a child that's not classified. It's always worse that a child is not classified and they do have a disability than maybe a student doesn't have a disability and they're classified anyways, because they can always exit out of the program. So I.D.E.A. prohibits the use of evaluation tools that discriminate on the basis of race, gender, ethnicity. Okay, you have to think about a lot of these tools with the languages that are used, the wording that they use, the type of questions. Use of a number of different evaluation tools are recommended. All right. So first you want to evaluate if the student's eligible for special education services, and you don't want to have misidentifications, and you don't want tools that discriminate. But what you want to use is a variety of different tools for evaluation, and that's what the law says. Okay. a number of different tools. So the law takes FAPE a step further to ensure that special needs children receive individualized education. Again, the word individualized is very important here, right? So FAPE was first guaranteed under the Rehabilitation Act, and it was also further established in EAHCA of 75, and it's cemented, we could say, in here in the I.D.E.A. So FAPE is such an important concept. So it's not only meant to meet a child's unique needs, but prepare students for life outside of education. So again, it keeps expanding the meaning of FAPE, right? Appropriate education is one where a student's education must meet the standards of the state education agency, while also including appropriate preschool, elementary, and secondary schools. So each state's education agency are going to have a number of standards, and like you can go to newjersey.gov, if you're in this state, and find them. And basically, it's up to the schools to make sure these students are meeting them, are meeting them and are getting an appropriate education. So the law requires that public schools create an I.E.P. for any student eligible to qualify under special education state and federal guide. If they're qualified, they're going to get the I.E.P. The I.E.P. is a legal document and must be followed. There's no debate, okay? Teachers are obligated to comply with I.E.P. directives. The I.E.P. is often described as the centerpiece, okay, for delivery of a child's special education. The I.E.P. is the blueprint of how schools should teach a child. So, what must an IEP include? Well, the student's present level of academic performance, annual goals, functional and academic related services that are needed, supplemental aids, for example, speech, if they need some sort of physical therapy, accommodations for statewide and testing, maybe they get extended time. The reason for placement exclusion with non-disabled peers, so you have to give a reason why. Maybe these children are placed in a separate school. There has to be a reason why. Time spent should be mentioned in the IEP. The time that they spend in a general education setting, and and it's worded usually as like 40% of the day, 20% of the school day. 80% of the school day, a child will be with non-disabled peers like that. Classroom modifications and progress towards annual goals. All right, modifications we'll get to that. We'll get to that soon. So here's just a nice little infographic I made of an IEP. Okay, and this is a short video. I'll provide a link here. So students classified as having a disability are given the IEP here, and this nice little infographic. All right, so students with disabilities must be educated to the maximum extent possible. Okay, with their non-disabled peers, right? So we talked about that LRE ladder, right? You want to get them to as high up that ladder as possible. Removal of special needs students from a setting with non-disabled peers is only acceptable if the student's needs cannot be met, okay? So that's only if it just can't work. If there's nothing you can do, then you would drop a student down a level of the least restrictive environment to a more restrictive environment, meaning more disabled children, okay, more special education students. Again, just another infographic I made on the LRE. So part of the IEA's dispute resolution guidelines include having due process hearings. Parents and schools have a right to an impartial hearing to present evidence, witnesses, and tell their story. Parents are given the ability to challenge any decision that they feel is unacceptable. I.D.E.A. issues a stay put provision. Okay, this grants grants that the child's rights to stay put in their school until the parent and school come to a resolution. So what's great about stay put basically here is that, if let's say there was a big behavior issue, schools can't just remove that student. They have to. The student's going to stay there while they make they can't just remove the student and then make a decision whether they stay or not. The student stays put until a decision's made. Mediation may be set as an alternative to due process. Okay, mediation is the process where a third-party mediator is brought in to resolve a dispute between the school and parents. That happens a lot too, and it's always cheaper than going to court or something. All right, so parents may file a civil lawsuit if mediation is not satisfactory, right? So this whole thing is, if they're trying to remove a student from a school here, right? You have the stay put provision, and then if the parents don't agree with the child being removed from the school, they can file a civil suit. I.D.E.A. states that schools must protect the confidentiality of academic records. Schools are allowed to share an IEP with the teachers and other you know relevant personnel, but they can't just make their information public. Okay, that's against the law. It's called FERPA. Okay, it's the short term, and it's the Federal Education Rights and Protection Act. Really important. Okay, it states that parents have the right to review any records they suspect are inaccurate on their children, and those records must be kept confidential from individuals outside of the school. This IEP should never be shared. Okay, never. And if you see an IEP, there's a lot of personal information on it. They have the student's address, phone numbers, parents' name, personal stories. That must be kept private. Must be kept confidential. Another short video I have here. There's no words in this one. This is just like an animation. All right. So I.D.E.A. includes procedural safeguards. Okay. Again, we're still on I.D.E.A. law to protect the rights of students with disabilities and their parents by providing the following below. So what are they providing? Translators to make language understandable. Okay, that's in the law. All right, just because a parent or a child doesn't speak the same language doesn't mean you don't have to try your best to communicate with them. Schools have to get a translator. Information on evaluations and requiring parent consent. Parents are afforded access to the child's records. Okay, we just mentioned that. Independent evaluations at the public's expense, and prior written notice where parents are notified of I.E.P. changes. Okay. Oh yeah, and lastly, parent participation in the IEP, right? So so the parent doesn't have to show up to the IEP. Many times parents can't make it, but they're always invited. So I.D.E.A. encourages collaboration between parents and teachers, which is a good thing, but it just encourages it. Remember that the parent is the most important source of information on the child. Parents have a right to contribute to the IEP meeting and make it, and be helpful. Students with disabilities must be provided with certain related services. Okay, so again, we're still on the IEP here. All right, so these related services include corrective therapy, speech therapy, occupational therapy, physical therapy, recreational services, so many different things. And here's just a little infographic I made of some types of related services: counseling, psychological services, transportation services. Okay, we don't think about that. That's important. PT, OT, speech. I'll just leave this here for a second. And notice here it says paid for by the district. Okay, paid for and found in a student's IEP. Paid for by the district, found in a student's IEP. So those are related services. Remember, we're still talking about this IEP. So, according to I.D.E.A., students with disabilities beginning at the age of 16 must begin transitional services. So, at the age of 16, they must, and this gets amended a little later on. Transitional services describe a student's transition. So, what are transitional services that we're talking about? Well, it's the transition of a student from high school to post-secondary life, and that could be a job, independent living, college, whatever. Transitional planning is basically used to help students figure out what they want to do when they get out of high school. Okay, they're developed on the basis of accentuating a student's strength. So whenever we're talking about transition planning, you want to accentuate the positive, eliminate the negative, help students avoid career pitfalls from their weaknesses, and get them doing something they're gonna like. All right, so like we said, this I.D.E.A. is continually it's getting amended. So let's look a little bit more now in 1997. Okay, so it was reauthorized here in so I.D.E.A. of 1997. It was the reauthorization of 1990. Okay, so it was so this reauthorization was implemented to improve special education with a focus on parent involvement and disciplinary consequences. And we talked a little bit about the stay put provision. So one of the major changes from this amendment was that the IEP evaluator was now able to look at previously collected data. All right, because evaluation team, the evaluation team wasn't earlier on they weren't allowed to look at the previous information, but it saves schools so much time, that you could look at previous testing, reporting, background information. Why not gather as much information as you can, right? So the benefit is that the child doesn't have to take these unnecessary tests and evaluations and assessments. Okay, we don't want to continually keep testing these kids, and it takes a lot of time for schools. There's also there's a reduced cost of evaluations as time and burden to school districts. If you can't look at anything old, and you have to constantly do new. There were a number of changes to the I.E.P. and the next slide is going to go over them. So this law highlights involvement of students with disabilities in the general education classroom, and specifically focuses on modifications and accommodations. Okay. It became necessary for general education to take part in, for general education teachers, I should have the word teachers there, to take part in I.E.P. meetings in the I.E.P. team. Modifications and accommodations are found within the I.E.P., and they differ from each other in that accommodations help students access the content, whereas modifications provide actual changes to the content. One second, what's up? Uh, I don't know. Did I eat the whole thing? I don't know. Anyway, all right. They differ from each other. Hold on one second. I can't go back. I'm not gonna go back. I can't go back and cut this because of the. Are you serious? Whoa, whoa, whoa. They differ from each other in that accommodations are given to help students better access the content, whereas modifications provide actual changes to the content curriculum. Both modifications and accommodations are an integral part of educating students' needs. So, a change in the content or learning goal of the student. All right, so it allows for here are some examples: allowed alternate reading materials, word banks, opportunities to retake quizzes, reduce problems. A change in the way a student can access content or tests, so preferential seating. Now, again, these are listen. Modifications are changing the content, changing the material. Let's say, right? So, look here. These are all the changing of the books, changing of the word banks, retaking quizzes, right? Where accommodation is how do they access, how do they get information here, right? So preferential seating is they're closer to the information, right? Extended time is they get longer access to the information. Open notebooks is they can view the information at different times. So that's the difference. It's very important to know the difference between the two. I listen. I mean, maybe I don't know. Honestly, it's probably not very important because they always get mixed up anyway. So you really don't. It's not that important to know the difference between the two, but at least you know it now. So this is an infographic I created here on the difference between an accommodation and a modification. The I.E.P. must be developed by qualified members of the school district, the LEA, right, the local education agency, and you know, like we said, it's like a board of education. So um, these qualified members must make up the I.E.P. team. Okay, and when I say local education agency, that means of the school, which it does include everybody. So you could take every. I mean, you could have child study team, you could have administrators, you could have principals, you could have special education teacher, general education teacher. So it's all right down here, right? So the qualified members make up the I.E.P. team and must include the following individuals below, right? A parent or guardian, special ed teacher, regular education teacher, a test interpreter, which is like an LDTC, a licensed disability, a teaching consultant. They do a lot of testing. A school representative, which is like an administrator or something like that. So here's the who of the I.E.P. team. Okay. So you've got a representative, a parent. If the student's 18 years old, they can be a part of the I.E.P. team. The general education teacher, test interpreter, special education teacher. Under I.D.E.A. 1997, the definition is used to determine eligibility of special education was redefined. Okay, so the definition to determine eligibility was redefined. For eligibility, evidence must be provided that not only does the student have a disability, but that disability must be detrimental to the student's educational performance. So it's not just having a disability; it must affect the student's ability to be successful. The push for more parent inclusion was reason in having an amendment. Was the reason in having an amendment to this existing I.D.E.A law. Remember, 97 is the amendment. It's the reauthorization. So, parents and guardians legally became part of the team in determining their child's eligibility. Parent inclusion. So before this, the evaluation team did not require the parents' involvement in making decisions. So before this, they didn't require it. There were a number of changes to the I.E.P. In 1997, they include testing accommodations for all standardized tests, statewide testing. Classroom paraprofessionals work closely with special needs students and must receive proper training. So now we're saying proper training for paraprofessionals, testing accommodations for standardized statewide tests. The PLEP was amended to require a HOW statement. And when I say PLEP, that's present level of educational performance. Sometimes you'll hear PLAF. So how the student's disability affects their progress in reaching the general education class. Remember, the goal is always to get them there. In addition, the PLEP needs to include a formal explanation on the extent that special needs students will not be participating with their non-disabled peers in both the classroom and after-school extracurricular activities. Students must be informed of their rights at the very least 1 year before they reach the legal age of majority, meaning no longer being a minor under state law. The rights are transferred from parent to the child. The I.E.P. also must contain a statement deeming the child has been informed of their rights of their transfer of rights. So again, this happens at when they reach the age of majority, meaning 18, so they're no longer a minor. Okay, and it's just a transfer of rights from the parent to the child. Schools are required to present progress reports. Okay. Beginning as early as now, it says, okay, remember earlier it was 16, right? It just mentioned the age 16. Now the age of 14 is mentioned. Okay, so before there was only the number 16. Now we're talking about 14, right? So beginning as early as 14 years old. So it says you could start, before it said starting at 16. Now it's saying you can start earlier. You can start at 14. So it contains a statement on the child's transitional services. And remember, transitional services, we said, that's when they're leaving high school to outside life. Okay. Mediation prior to hearings was incorporated into I.D.E.A when parents and schools cannot come to mutual agreements. The state will supply the mediator and impartial individual to resolve the placement or to resolve the disagreements between parents and school districts. A major component of I.D.E.A is what's called manifestation determination, a review of the student's behavior, which is an investigation into whether or not the student's behavior is simply a result of their disability. So you want to know, are they misbehaving because of their disability, or are they misbehaving just because it has nothing to do with their disability, right? And if the student is misbehaving because of their disability, then you can't blame the student. It's not the student's fault, okay? It's their disability. If the student's just misbehaving just to have fun, then okay, then you can. If he's misbehaving just because he wants to, then you can go forward with punishments. So manifestation determination is to be used before school suspends or expels a special needs student. So if a school's thinking of expelling a special needs student, they have to look and say, okay, is their behavior a result of their disability? And if it is, or if it isn't, if it isn't, then go ahead and do whatever. But if it is, then you have to do an investigation, and they usually do behavior plans and functional, or maybe change in their environment, or because you can't blame the kid if it's a result of the disability. So very important, the reviews are conducted by I.E.P. teams and required to take place within 10 days of the behavioral incident. So you only got 10 days here to review. So the review will investigate the following. If the improper behaviors resulted from inappropriate placement or it being in a detrimental educational program. So why, right? Was it a poor placement? Was it a bad IEP? Whether or not the child's disability impairs the student's understanding of consequences, okay, that follow. Maybe the student doesn't get what's going to happen afterwards. Is the disability responsible for the misconduct that led to the disciplinary action? These are all questions that have to be asked in the manifestation determination, right? So you want to find that. So if the manifestation determination reviews find that the misconduct was a result of the disability or the child being in the wrong placement, then the school district does not have the right to expel that child. Okay? It's not the child's fault. Although a change of placement will be acceptable, okay, they can move the child to a better environment, but you can't expel them. Expel them. If there is no relationship between the disability and the inappropriate behavior, then schools are allowed to apply disciplinary action. Okay, so if it's not related. All right, so here are a bunch of good videos I made on functional behavioral assessment. This is all stuff that are often used for students with disability problems, and the FBA is used for the why of behavior. Same thing with the ABC charts. You look at what happens before, during, and after the behavior. And behavior intervention plans are very useful as well to put children in the best spots to succeed behaviorally. So, schools were allowed to take strong disciplinary actions and place students in interim alternative education settings against special needs students in the case of the student being in possession of or having distributed illegal drugs. So things are different if the student is selling drugs in the school, obviously. Okay. Students. So again, if the students are selling drugs or something like that, then you can expel and do things. So there are limits too. All right. So students with disabilities will take standardized tests, but those tests, again, we're still in I.D.E.A. 1997, right? The reauthorization. Those tests will not be able to hold them back from graduation. There are many pros and cons of standardized testing, and I agree with that. There are really good things, and then there's bad things that come with it as well. But I think the pros outweigh the cons. So here's a video on the pros and cons I made. I'll link this too, so you can just have an idea of. And this is really geared towards special education as well, how it affects them. Sorry, I didn't mean to play this here. Okay. So, all right, we were in I.D.E.A. right now. We're onto this law, the No Child Left Behind Act, NCLBA. Okay, so earlier we talked about the Elementary and Secondary Education Act early on, right? I think that was like the first one we went over. So this No Child Left Behind is an amendment to the original one, and it was ultimately replaced. So No Child Left Behind in 2001 gets replaced by Every Student Succeeds Act of 2015, and that's still in place today. This law was created with the collaboration of Democrats and Republicans in an effort to help underachieving minority students. So everybody got together to help. Here are some pros and cons. Okay, so No Child Left Behind, they put pressure on bad schools, puts pressure on schools with bad teachers and weak administrators, but there's too much emphasis on test scores. So this is really from teachers, what teachers think. Okay, that this law focuses too much on test scores, but the good thing is the law puts penalties for schools for not really doing their job. But then schools say, we're in a tough spot. So we'll get into this here. This law is Public Law 107-110, and it was signed into law by President Bush in 2012. The main purpose of this law was to place accountability on schools to deliver academic success for their students. School choice stands out from this act, which is the idea is that all students should have opportunities to attend successful schools. The law emphasizes standardized testing in an effort to identify lagging schools that are failing, and students at risk. So it wants to target those schools, and it wants to help them out, and if it wants them to succeed, and if they don't, well, then the state could take over. The law requires that all states test students in mathematics and reading in grades 3 to 8. So the students must be tested, and students are required to be tested at least once in high school. In high school, at least once in math and reading. 1 second. All right, so public schools are required to make improvements and achieve success. So the bar is set high here. Parents, teachers, and administrators argue that it is unnecessary pressure on school personnel. They think it's too much pressure. The premise is that all students will be able to demonstrate proficiency in math, reading, and science. They, it's a high goal, you know. It is. So, No Child Left Behind presents new choices for students and their families, and often looks to foster the growth of chartering schools and provide protections to parents at homeschool. Okay, those are always options. If a child attends a failing school or one that is in need of improvement, that child can choose other public schools to attend to as well. And even if the child isn't failing but the school is unsafe, parents have the option to attend another public school for their child, to have their child attend another public school. So states and school districts must provide relevant information to parents to make their decision on school choice. They do that, they do that by report cards, we'll get to. This act provides more flexibility on how states and schools can spend their money. Okay, because every state is different, every school is different, the needs are different. So flexibility is good. Prior to this law, schools and local education agencies continually complained about the amount of unnecessary paperwork. This way, more power and decision-making abilities were given to local educators because they know the students, right? So you want them making the decision. And one of the complaints, like I said, was too much paperwork, and I can attest to that. So I definitely agree with there's too much paperwork in education. So each state sets goals for their students to meet, such as increasing standardized test scores, attendance, graduation rates. Those are just as important. Showing up, graduating. Failing schools must meet the minimum benchmark for student achievement, or if they don't meet that minimum, or they don't reach that minimum benchmark, they can be taken over by the state. Schools are required to make AYP, annual yearly progress, towards their goals in math and reading. AYP is determined by the states as they choose the lowest achievement demographics as the starting point and require a minimum increase each year. The No Child Left Behind Act was meant to improve education for all students regardless of their economic status, their ethnicity, the gender. Okay? Schools must meet their AYP, their annual yearly progress marks, in an effort to close achievement gaps. Again, this is like No Child Left Behind just set the bar really, really high, which was a good thing, but it was also tough to make, right? So students can raise their AYP targets each year. Sorry, states can every year they can raise the target of annual yearly progress for the schools. And here's just a little infographic. You could pause this, take a look at it yourself on AYP. So again, right, school districts are required to make an annual report, right? So if parents are going to make decisions about where they're sending their school, you got to make these reports out there. So they got to make these reports to the public on their achievements and shortcomings. The report must present performance data and disaggregate the data based on grades, schools, overall district. Districts present report cards that show AYP for subgroups based on race, gender, so you can see if there's something's going on wrong. You can see if there's discrimination. So under No Child Left Behind, special education teachers are required to meet highly qualified status. Okay, to do that, they must be state certified or licensed. Okay, like in New Jersey, we have what's called certifications, but in New York they have licenses. So certification, licenses, different terminology. There's a minimum of a bachelor degree, proof of knowledge of a specific subject they teach. That's the most important one. So if you're a special education teacher and you're teaching high school math or high school biology, I'm a special education teacher, but I'm also a high school biology teacher. So I was general education teacher first, and I have a K-12 certificate in biology. So if I teach special education biology, I have my K-12 certificate in biology, and I have my special education certificate. I'm highly qualified to teach biology. Same thing with mathematics. I also have a K-12 mathematics certificate, so I can teach K-12 general education math. But I also have my special education certificate, which is known as a TO, a teacher of students with disabilities, a TOSW. So when I put those together, I'm also highly qualified in mathematics as well. Now, previous to me getting those licenses, other teachers are what's called grandfathered in under what's called the TOH, That was before this law. So the teachers before this law, a lot of them are grandfathered in. This law is designed to make special education classes comparable to general education classroom, right? Because it used to be the general education classroom had the teacher that knew what they were doing, and the special education teacher didn't know. Now they have to both know the subject. The law puts in place hiring standards for paraprofessionals, specifically with Tier 1 funding. Paraprofessionals must meet one of the following standards: complete a 2-year study at an institution, possess an associate's degree or higher, or demonstrate through formal writing an ability to help their students in reading, writing, math, something. So one of these. Well, the definition of research based is narrowed and must involve objective procedures and valid knowledge relatable to educational and institutional programs. Federal funding is used to target research based instruction programs that have shown achievement. So, research based, you got to prove achievement. Okay? Prove achievement. The importance of fundamental reading skills and the abilities is brought to the forefront in No Child Left Behind. Reading teachers from kindergarten to third grade are required to use research based instructional strategies. Teachers should be looking to strengthen previously learned skills and help students acquire new reading skills. Okay, reading is, I can't stress how important it is. So, children that begin with a solid foundation for reading are much more likely to be successful later on in reading and other subjects. Under No Child Left Behind, resources and funding are set aside specifically for early childhood intervention. States opting into the Reading First program, which is great, may receive funding from early reading program for use in Head Start programs. Head Start programs are wonderful. The importance of having safe schools is highlighted by increasing funding for drug and violence prevention. Okay, and that's, again, we're in the No Child Left Behind Act, so we're focusing on that. It is recognized that schools must be safe in order for children to succeed academically, and no child wants to go to an unsafe school, and teachers, nobody does. Students are afforded the opportunity to transfer schools if it's unsafe. If schools do not meet their annual yearly progress, okay, the following consequences. So, all right. So again, right, we're talking about No Child Left Behind, and they have all these you have to meet this AYP, and if you don't, you're gonna get slapped with some consequences. So let's take a look. So a school that misses AYP for 2 years in a row must allow their students to transfer to a better performing school, and must pay for the transportation. If they fail for 3 years, the school must offer supplemental educational services, which are free tutoring, summer enrichment, etc. 4 years of failment, 4 years of failing, schools must either replace the staff or change the curriculum. All right, and listen, you can see every year it fails, the punishment and not the maybe not the punishment, but the need for the change is intensified. So in addition, the school becomes put on what's called a corrective action plan. And if the school doesn't meet AYP for 5 years, okay, there's the following options. Okay, the state gets taken over. The principal can be replaced. The school can, the children can have chartering schools instead. So here's a little video I made on No Child Left Behind. It's just a short summary. Okay. All right, so I.D.E.A. Improvement Act, okay, 2004. Okay, we continue to improve on I.D.E.A. Let's keep it going here. All right, we get a little more coffee to keep this going. All right, so the improvement, so I.D.E.A. was changed and it has an extra I in it now. You can see, so instead of the Individuals with Disabilities Education Act, it's Individuals with Disabilities Education, and I put that little I in there, Improvement Act. So the word improvement is thrown in right before the word act. And the purpose of this is to further support, was to provide further support that was needed to prepare special needs students for life outside of school setting. Okay, and that's the most important thing. So I'm glad that you might say, oh my God, they just keep changing this and keep changing this, but it's always for the good though. So I.D.E.A. continues to push for students with disabilities to be granted maximum access to the general education curriculum. That's nothing new. We've been talking about that. So it established being a highly qualified teacher, which what we talked about before. And the new requirements for special education secondary teachers, that's what I was when I was talking about, was that They must hold a bachelor's degree and a full state special education certification. So if you saw when we were talking about No Child Left Behind, they talked about highly qualified teachers, and now we're getting to a little bit, it's a little bit more detailed here, and you can see with focus on secondary teachers here in the 2004 law. So special education teachers in core academic subjects must prove, okay, they got to pass that. So I had to pass like my praxis tests to get my certifications, okay? So special education teachers that consult do not need to prove subject mastery. So if you're a special education inclusion teacher and you're not teaching subject, you're just there consulting, then you don't have to prove subject mastery. But if you're teaching like I am, like biology, then you've got to prove that subject mastery. And I had to pass the praxis test and, take all my credit and all that fun stuff. So this law pushes for high expectations for special needs children through increasing exposure to the general education classroom. Everything, okay, we want to get these children, maximum time in the general education classroom. FAPE is now expected to emphasize special education and related services that prepare students for independent living, employment, and further education. Again, right, the focus here in 2004 is for special education students outside of school. After they graduate. So the definition of an assistive technology device was amended to exclude devices that are surgically implanted, specifically cochlear implants. The law made clear that students with assistive technology devices cannot be prevented from having special education services, and schools are not responsible for implementation or removal of the surgically implanted. So, if a child has to get their surgically implanted device removed, the school doesn't have to pay for it or to pay to put it in. All right, so I.D.E.A. defines the term assistive technology as a device, as a piece of equipment that is used to increase, maintain, or improve functional capabilities. So that's how I.D.E.A. defines assistive technology, right? So here's a nice little infographic. It doesn't include medical devices surgically implanted. It increases productivity, used for vision, hearing. I could pause that. So for some students with disabilities, using printed materials are a barrier to access. So that's good for blind students. I.D.E.A. 2004 asked each state to follow the National Instructional Materials Accessibility Standards, NIMAS. Ensures that students that need educational materials in the form different than print will have access to those materials. Okay, and I think I have a link. I thought I'd link this here in the presentation. I have a link to like their website. I.D.E.A. 2004 defines the different categories of students with disabilities. In 1990, autism and traumatic brain injury were added as new categories. There are currently 14 different categories, but it's kind of 13. I have a full video on that because I forget which one. One of them doesn't last. It's just for I think to age 9. It might come up here. So students that fall into these categories are eligible for special education. So here's the video here. It's got all, I believe, 14 of them, and developmental delay I think stops at age 9. So it's 14, but it could kind of be like 13. All right, so these are the 14 categories that are out there now. You can take a look at them. This video will go over everything. I'll link that above if you want to get some detail on that. So the definition of a child with disability was used to describe children from ages 3 to 9 with a developmental delay. Now that definition was amended to include Tourette syndrome. Tourette syndrome is a neurobiological disorder characterized by tics and verbal outbursts. And it's directly added to, so we're talking about Tourette's now, was directly added to OHI, which is a category of students with disabilities, right? I.D.E.A. Provides several changes to evaluation requirements. Okay, parent consent is required for special education evaluation services. Parents must sign off on an evaluation before they start for special ed services. I just had to go over that recently for my son. So I.D.E.A. provides several changes to evaluation requirements. The time allowed between the request for an so the time allowed between the request for an initial evaluation on determination of a disability was changed from 60 days to 60 calendar days, okay, from the start of the request. And no single assessment tool should solely be used to determine qualification, right? So it can't just be one tool, and it was changed from 60 60 days to 60 calendar days. And I think that meant 60 school days. So I.D.E.A provides several changes to evaluation requirements for determining the category of specific learning disability, which is a high prevalence, high incident. So it's very prevalent. Um, so the criteria allows for both discrepancy between achievement and intellectual ability, as well as whether or not the child responds to the school's intervention program. So it's really two things here. Due to this change, some students that don't meet eligibility through testing, they can meet through another criteria. So it sort of makes it more inclusive. Evaluations for disabilities may include classroom observations, state testing, and overall academic achievement, right? Um, the Improvement Act provides several changes to evaluation requirements. Assessments and evaluations must be in the child's native language. Assessment tools must also be non discriminatory and removed if there's any cultural bias. The assessments must be conducted by individuals both knowledgeable and trained to conduct the assessment, and parents are entitled to use private evaluations, but the I.E.P. does not have to accept their recommendations. So the parents can pay for their private evaluations, but the I.E.P. They don't have to. The school doesn't have to accept the private evaluation though. But they can review it and stuff, but they don't have to accept it. The definition of PLEP was amended to include not just the child's present level of academic performance, but functional performance, right? So, present level of functional. Short term objectives and benchmarks are no longer required on IEPs, with the exception of special needs students taking alternative assessments, and goals should be written based on academic progress to standards. I.D.E.A provides several changes to the IEP. When special needs students transfer schools, the new school must offer services comparable to that of the old school district. The notice of procedural safeguards now only has to be distributed to parents once a year in an effort to cut the red tape. Okay, I.D.E.A provides several changes to the IEP. IEP meetings are allowed to occur in alternate ways, such as through video conferencing and other means. So, and that's really good now with the social distancing that's going on due to the pandemic. After the IEP meeting has taken place, laws and amendments to the IEP without need for another meeting. I'm sorry, let me read that one more time. So after an IEP meeting has taken place, I.D.E.A law amendments to the IEP without the need of another meeting taking place. So you can't do that. I.D.E.A provides several changes to the IEP. The law grants exceptions for the meeting attendance, such as team members submitting written accounts of student academic progress. The definition of an IEP team was changed, where it now states that no less than one special education and general education teacher should participate. And the IEP's team's choice of related services must be based on peer-reviewed research. Okay. Oh. All right. So I.D.E.A provides amendments to offers amendments to transition planning. Earlier requirements listed having transition planning begin at age 14 now states that it must include transition planning in the first IEP that will be in effect when the child turns 16. Okay, so it's another change. Just with timing of the IEP. Remember, at first it started at 16, then it was to begin at 14, so now it changes a little bit. Transition planning must include appropriate post-secondary goals and assessments, and the goals should reflect student strengths and interests for future success. Okay, let's keep going here. 1 second. Sorry. Where was I? All right, so I.D.E.A lays out additional procedures for disciplining students. Students are allowed to consider unique circumstances. Schools are allowed to consider unique circumstances of students' behavior on a case-by-case basis. When schools discipline a student with a disability by having the change of placement, they must notify the parents on the same day with a written copy. and a pattern of removals that are up to more than 10 days constitute a change of placement. Very interesting. Under I.D.E.A, if a student is to take an alternative assessment, as recommended by the I.E.P team, a statement of explanation of the reason why must be in the I.E.P. Special education teaching certifications or licenses didn't ensure content mastery, but now the standards have become raised. And special education teachers of today are better for it. Okay? So because we raised the standards, special education is better because we have to have content mastery now. The inclusion movement, okay, is a big thing right now. It's the belief that students with disabilities belong in the general education classroom, and it's based on the idea that there's no excuse for leaving special needs students out of the general ed classroom. And it's at the heart of all laws being mentioned in this presentation, the inclusion movement. And it led to classroom collaboration between general and special education teachers. And these in-support classrooms are advantageous for special needs children. They perform much better. Here's a great video I made on this, and here's a little infographic I made, not from that video, but I just sort of made. So, no excuses. The school's got to make it work with this inclusion movement. So every student succeeds acts. ESSA, right? So we're getting to the end here. All right, so this was passed in 2015, and it replaces No Child Left Behind, and it makes several important changes. Okay, every student looks to decrease the amount of high-stake testing by allowing states to make the decisions. Okay, again, we're giving more power to the states, and ESSA provides funding for states to improve the use of assessments in a way that's beneficial to the child. It eliminates that AYP that schools had to meet, and I bet a lot of schools weren't making it. And it was, a lot of teachers have bad things to say about No Child Left Behind. A lot of teachers have good things to say. So that AYP is gone. States are required to submit goals and plans for achieving their goals to the U.S. Department of Education. So they got to submit planning goals. The Department of Education is obligated to provide feedback and approve or deny the state's plans. And states are still held accountable as their students are subjected to standardized tests. So states are still held accountable. ESSA aims to prepare all students for post-secondary life outside of K-12. That theme keeps coming up. The law states that regardless of race, gender, sexual orientation, students should be well prepared when exiting high school. Schools must offer student college and career-ready counseling, as well as advanced placement classes. So that's what schools must do, and that's great as well. Bullying prevention programs are put in place. Special needs children are often the targets of bullying. Many states have their own laws and rules to put out. Schools mostly have bullying prevention teams today. It was a long journey to get to this point. Special education hasn't always been kind to children. Special needs children of today experience many luxuries and accommodations that earlier generations missed. So, I'm really tired here. There's so much to go over here now. It's rushing through this presentation, and it's really in depth. So, but you see all the changes here that we have come a long way. The parents of special needs children were the ones mainly responsible. These parent advocates put pressure on local politicians to put this legislation forward. That's why we're in such a good position now, although the fight must continue. Early in the 1800s, children with special needs were denied the opportunity to attend public schools. At the time, separate and isolated schools were terrible. And, not so long ago, children were forced to remain in classes with other disabled children. So this inclusion movement and push is a great thing. A short video on the history of special education. Here's an even shorter thing. So some of our laws here. So, in the 1800s, a lot of them had no school. Then the 1850s was isolated schools, separated classrooms in the 1920s. And I told you that 1975 was a really important year. I'm talking about I.D.E.A, Education for All Handicapped Children Act, at least, all that stuff started to come. So before I finish here, there are a couple of cool landmark cases that are really important in special education I'm going to go over here. All right, so we'll start with this one. Brown versus the Board of Ed in 1984. Such an important case. And it's not just about special education, but essentially it was a decision against segregation based on race, on the idea that separate but equal. So the idea of separating individuals on their race was deemed unconstitutional. The case is an important landmark in the civil rights movement. So even though they say separate but equal, it wasn't equal. The white schools had it much better than the black schools. And anybody could have seen that. So Brown versus the Board of Education had a positive impact on special education because not only did it apply to race, but then we started looking at it for people with individuals with disabilities. A Board of Ed, Henry Hudson versus Rowley. Amy Rowley was a deaf student whose high school district denied providing her a sign language interpreter, right? So she was a deaf student and she wanted a sign language interpreter, but she was doing well already, and and she did better with the sign language interpreter, but she was already passing it and doing well. So the parents of Amy argued that the interpreter was necessary for her to reach her FAPE, but the Supreme Court decided in favor of the Board of Ed, stating that uh, schools don't have to ensure that students meet their maximum potential. They just have to do the base floor. So Amy, the student, was passing, and that's all the schools has to. They and it doesn't make sense. Not every child's not a school can't be responsible for making sure every single kid reaches the maximum potential. It's just too hard. At the very least, the school can do the basic floor, as they say, and I think it's the right decision. Smith versus Robinson, the case centered on reimbursement fees for the lawyers for the parents. Granted litigation, if it was a win. So at this time, I.D.E.A. didn't insist on reimbursement, but if the parent sues and they win their case, then the school has to pay for the lawyer fees. After this case was ruled upon, Congress passed a law awarding reimbursement to parents for lawyer fees if their case is won. Mills versus the Board of Ed. The court ruled that students with disabilities must be afforded a public education even if they can't pay for it. Okay. So the law predates the Rehabilitation Act of '74, which I went over, where students with disabilities are guaranteed protections if they attend schools that receive federal funding. We don't talk about private schools. The Mills case led way for FAPE and the Education for All Handicapped Children Act. This is a good one too. Irving Independent versus Tatro. So Amber was a student that had spina bifida and required a catheter during school hours. So the question was whether the catheterization was considered a medical service not covered under I.D.E.A. or related service covered under the I.E.A. So this Amber needed catheterization just to learn. And so is it being paid for? Who's paying for it? The court ruled that the school board had to provide catheterization and pay for it because this child needed catheterization to learn. Whereas with the Amy case with the sign language interpreter, the school didn't have to pay for that because she was already learning, Amy. In this case, Amber needed this just to go to school. So schools have to provide an education, and in this case, this was the right decision as well, I think. The next one here, the case of Doe, an emotionally disturbed student in San Francisco was suspended indefinitely for inappropriate behavior. The ruling stated that schools cannot expel students if behaviors are related to their disabilities. We talked about this. Okay, schools cannot suspend students if the reason for their behavior is caused by the disability. This is the state put provision I talked about. Park versus Pennsylvania. Park sued the public schools in Pennsylvania over a law that granted permission to deny. So you see, they did deny children a public education at the age of 8 if they didn't reach academic ability of a 5-year-old. So if an 8-year-old wasn't as skilled academically as a 5-year-old, they could deny that child's school. So, I mean, this is a no-brainer here, right? The court ruled that schools cannot deny a child public education. So this was happening. And I don't have the date on this, but I think it was in the 70s. All right, so here we go. So this is just a little overview from one of those earlier videos. Okay. Okay. So this is all the works cited. There's a bunch of them here. These are all of them. I mean, whatever. It just keeps going and going. But all right. So anyway, I want to say thank you for staying here. This is a long presentation here, so I rushed through it and I lost focus here, and I haven't eaten, and maybe I've stumbled over my words, and maybe I've misread things, and I apologize for that. I didn't realize how long it was going to be. So for the next time, maybe I'll cut it into parts, or I'll try to be energized here. Sorry about Sorry about that, but thank you for staying along with this. I'm gonna try to do another one here on the next one will be on like special education teaching. Um, but all right, guys, I'll see you soon.